it started, I mean, I was looking and I was like, wait a minute, that's, because I thought it was a cap of 2 on the TDC case. I'm like, what? Okay.
Yeah, I forgot there were different levels. Luke talked in the state, I thought there were different levels.
Okay.
Do you want to plead Hendricks now, or do you want to do them when we do the other day?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
Yes, sir. Judge, if I can, there's no family members here on the side team.
Yeah, which one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is Harmon. This is
What
Harmon.
did I?
This is Harmon.
Oh, that's why I'm, never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So wait.
Miss, okay, we're going on all of the counts.
Whatever
Or
makes
at
it
least,
third.
okay, got
Whatever
it.
gets us with their judges.
Okay, I got it.
I think we're gonna need all of them to get us to.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Yes,
All right, good luck to you, ma'am. You can go back with the bailiff. I thought I printed, my printing thing is being, okay. Let's see, let me take care of Mr. Armstrong real quick, and then I'll take care of that sentencing. Colton Armstrong, Mr. Kimler.
We're pleading this as a third degree.
Thank you.
He's gonna have to plead true to anything else. I guess there's some first.
No, I
don't mean just here.
Good morning. Are you Colton Armstrong?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So wait. One, two.
Mr. Armstrong, in cause number 25 DCCR 0002, you're charged with the state jail felony offense of theft of property from February 21st of 2024. Your indictment alleges that you were previously convicted of the state jail felony offense of driving while intoxicated with a child passenger, October 31st of 2022, two cases on that same date of that same offense, making this a third-degree felony punishment range. And how do you plead to that charge?
Guilty.
And are those two prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would not be a fine, but you would be ordered to pay restitution in the amount of $20,000. Is that your understanding?
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Armstrong is not competent?
There's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to bond?
Judge, may I just put one thing on the record first before that?
We're gonna come back for some.
Obviously, I was a little bit hesitant to make this offer based on those priors, and I just want Mr. Armstrong to be aware, I have relayed this through his attorney, that if he does not pay this restitution back, I won't be asking for the minimum that I offered him today, 15 months. I'm going to ask for 10 years based on the opportunity that he's been given. I don't know that he doesn't have a hold in Hardin County. I'm not saying that disrespectfully. I just want him to be aware of what he's just gotten himself into if
Sure.
the court follows the PSI. So I don't know if he has any holds.
I believe he does.
I'm a little hesitant to allow him on bond before you review the PSI, but I'll defer to what you think.
It sounds like based on that, and there is a hold from another
I
county.
can't say that they put a hold on him. I don't know. I know he has pending cases in Hardin County. I can't speak to whether there's a detainer on him from Hardin County.
And I've tried to reach out to Mr. Hopper over there and not that much.
Trying to flood.
Bruce.
He does have a pregnant wife, Your Honor, that's due fairly soon.
31 weeks.
31 weeks. Almost said 31 months.
Oh my gosh, wouldn't that
Feels
be?
like it was.
It does.
I wouldn't know. I think the two, he has an unauthorized use of another vehicle and a theft of the same vehicle in Hardin County.
He does have 2 Hardin County holds.
So those would have to be cleared as well.
Yeah, and by the time, I'm afraid if I set a bond and then they get them over here, then we're not going to get the PSI. It's just going to prolong everything. And I think I'd rather go ahead. I'm not going to adjust the bond at this time. Let's get it taken care of. And then as soon as sentencing gets here, if everything goes well, you'll be released, at least from our custody, and then you can go take care of your Hardin County cases. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you. Who's crying? I haven't even done anything to, I haven't even been that mean yet today. But I'm about to. I would probably be too. Mr. Lewis, Christopher James.
Courtroom proceedings often appear routine, but this hearing demonstrated how a single paperwork mistake can change everything. Before accepting the agreement, the judge carefully reviewed the documents, noticed inconsistencies, and immediately stopped the proceedings to prevent an incorrect sentence from being entered. Moments like these highlight the importance of accuracy and due process in the justice system. Judges, prosecutors, and defense attorneys all share responsibility for ensuring court records are correct, because even small administrative errors can have major legal consequences. While this pause may have seemed unexpected, it ultimately protected the integrity of the case and ensured the defendant's sentence would be based on accurate legal documents.